Hey everyone, it's Professor Morris, and welcome to the week 2 class lecture review, where I'm going to kind of take some time to go over the week 2 class lecture and kind of focus in on some major points that I want to add some sort of context to provide a little more detail, some explanations, because some of this stuff, if you just read it, the words on the paper, it does come across as a bit legally dense and kind of difficult to understand because the words sometimes don't always kind of match up with the meaning. And so it's not easy to kind of discern what the terms mean based off of how they sound or the way they read, or even in some cases the context within which you read them. But anyway, we're gonna take a little bit of time to kind of go over some of that stuff, and in the process, help you answer the questions that are going to be on class exercise 2, and hopefully not create any additional issues. We do have a midterm coming up. That's another reason why I want to kind of do a little more of these videos for every class lecture, every written class lecture, is because this class is going to move quickly. It's an express session course, as you know. And so we've already got the midterm coming up next week, May 30th, Thursday, May 30th, where you'll have the entire day on May 30th to take the test. However, once you start the test, the clock for the exam starts, and you have 75 minutes from the time you start the exam to finish it. So even though there's no set time for when you have to sit down to take the test, it's a timed exam. I don't want anybody to get the wrong impression on that. So you're going to have 75 minutes to complete the exam. Once you start it, you can't stop it or pause it. So make sure before you take your midterm that you are in a place where you've obviously got good internet, where it's quiet, where you can concentrate, where you can knock the test out, and hopefully get yourself a good grade moving forward into the second half of the course. The midterm will have 25 multiple choice questions on it only. And it'll be based off of the material that we've covered in the first 3 weeks of the course. No mysteries there. In fact, there shouldn't be any mysteries with regards to what's going to be on the midterm exam or even the final exam for that matter. And the reason is, number one, um, I designed the course that way. I want you to be able to learn this material without having to, stress out over exams. And I know some of you have exam or test anxiety, and look, I get it. I have the same problem myself. Have for years, even through grad school and law school. It was never easy. So I completely empathize, and because of that, and because I want you focused on learning this material, that is the number one priority in this course. It's not to test you to death. It's not to test how smart you are or how clever you are. It is for you to learn this material. So I'm going to spoon feed it to you. And so if you think this class is easy, that's by design. I'm not, it's not just because I'm a nice guy or trying to earn favor. It's because I want you to learn this stuff so that you can go out into the world and get yourself a good job as a paralegal or legal assistant, uh, and um, and be able to uh, talk during an interview intelligently about some of these topics. And you can't do that unless you know what these things truly mean. Uh, and trust me, attorneys and other paralegals who will interview you will know whether you're BSing or not. So it really does help your chances later on in your career if you gain that sort of foundational knowledge now while you're in training, while you're in school, before you head out into the real world and try and gain employment. So again, midterm 25 multiple choice questions coming up May 30th, Thursday, all day to take the test. But once you start the test, 75 minutes to complete it. And in addition to me kind of spoon feeding you the information for the exam, part of that will also be a study guide that I'll release uh, probably at the beginning of next week, because we still have one more one more lecture to go, the week 3 class lecture for the midterm. And so I want to make sure where we are as far as the material we've covered before I release that study guide. So just keep your eyes open for that. Trust me, you'll know when it hits. I'll post an announcement on it, and that'll be available for you as well. And I'll do the same thing for the final exam also. But that doesn't mean you don't need to complete the class exercises. Those are worth 20 points each. Okay, that's obviously you miss one class exercise, that could be the difference between a letter grade. So you really, again, don't want to take a week off, even though it's summer. This is an express lesson course. We have a lot to cover. The material is going to get even more dense as we move deeper into the course and into the material. So just keep in mind that right now we're starting off slow. We're kind of getting, the training wheels are coming off, and we're going to start moving faster after the midterm exam. So keep that in mind. Now let's talk about the week 2 class exercise, or excuse me, the week 2 class lecture, and I guess class exercise too, because again, this will hopefully help you kind of better understand and do well on the class exercise when it comes to answering those questions. And I'm just going to kind of go through some major points that I want to emphasize. And as you know, if you haven't read it yet, you will hopefully by the time you see this video, that this week we're talking about the comparison and comparative differences between a deed and title. That a deed is primarily the paper version of title. It is the written document. In fact, it's a requirement that all deeds have to be in writing. They have to be on paper. It can't be a digital document. And the reason is because you've got to have notarized signatures. Now, yes, you can notarize an electronic signature, and we'll get to all of that a little bit later when we get to the formalities of property transactions. But just know that as the date of this video, the Florida law is that all deeds have to be in writing and they have to be on paper. Also, there are some formalities when it comes to a deed. In addition to it being on paper and being in writing, there are some signatures that have to be notarized. The buyer, the seller, as well as a witness. That witness is usually the notary. And remember our lesson on notarizations when we did our little identification notarization form at the beginning of the course. That is something that obviously is going to need to happen. All signatures on a deed have to be notarized. Now, remember, a notary doesn't attest to any of the information in the deed. It is simply an attestation that the notary has confirmed the identity of the people who've signed the document. That's all a notary does. It doesn't have anything to do with the actual contents of the document. But there's another important formality of a deed that I want to kind of go over, and we'll talk about title in a second. And that is what's known as a valid legal description of the property. I didn't get a chance to go over this last week because I pulled the slide, but then forgot to show it during my lecture. And that is this idea of what a property legal description is, and how they work. And here's what I'm talking about. There are primarily two types of legal descriptions in a deed. There's something called a lot and block legal description, and then there's a meets and bounds legal description. A lot and block legal description is usually a lot shorter. It's easier to read. It makes more sense. And basically, it is based off of this concept that all land developments before property is developed, in other words, before they kind of remove all the trees and do the landscaping and build the homes or office building or whatever it is that they're building on the property, before that property is developed, it is basically cut into giant squares, giant blocks, as they call them in property law. And these blocks then are kind of divided up into smaller blocks known as lots. And so when you look at this property description here, based off of the lot and block description, you can see that it just simply says lot 9, block 58, Scott Lake Manor, Section 8. Scott Lake Manor is the name of this development. And usually these developments have a name that is synonymous with the area that the development is in. And so, and again, this could be in any city, in any town. But you can see here, it later says at the end of the legal description, Miami-Dade County. So you know we're in Florida, and you know we're in the Miami-Dade area. But Lot 9, Block 58 is the exact parcel lot name and block number and name of the place where this particular piece of land is located. And you also will notice that there aren't any meets and bounds. There aren't any, this isn't any measurements on this. This is simply where this property is located, the lot, the block, the development area, and then where it says Plat Book 65, page 117, that is the book and page number of where this deed is recorded. And something that I allude to in the written lecture, and something that you will come to know, because I will repeat it over and over again from this point forward, is that deeds have to be recorded. They have to be recorded at the courthouse in the jurisdiction where the land is located. And it is this recording that gives a deed its legal power. Now, it doesn't mean that if you have a deed and you haven't recorded it at the courthouse, wherever the property is located, that the deed isn't valid. It just means that enforcing that deed is going to be more difficult, because when we talk about doing a title search, something that I'm going to show you how to do in this class later on after the midterm, but something that I allude to in the written lecture in week 2 is, in order to do a proper title search, these deeds have to be recorded. You have to know all of the people who have owned that lot and that piece of property throughout time, ever since it was developed and sold. And the way you do that is through recording. And these courthouses now, because of the internet and digital technology, have the ability to kind of talk to each other electronically. And so even if somebody who owns a piece of property, say in Miami-Dade County, doesn't live in Miami-Dade County, but lives in Ohio, and maybe for some reason that's where they recorded the deed, even though that's not where it's supposed to be recorded, you can still find that out. You can still, kind of figure that out based upon the fact that all of the courthouses now kind of talk to one another electronically. And so property recording and title searches are a big part of property transactions, because you want to make sure that a piece of property is owned free and clear, or what is known as free and clear title. Something, again, that I allude to in the written lecture, something that we will talk about in more detail as we go through the course, which is that, when you buy a home, for example, usually you get a mortgage for 10, 20, maybe even 30 years. So, you're going to pay, your intent to own this home could be for maybe your entire lifetime. In fact, quite often property is transferred from one parent to a child, and then from that child to another child, and so on. And so property can stay in a family's in a family and in their estate for many generations. And that's important for a number of reasons, but one of the big things that can happen over the course of a person's lifetime is if they need, let's say they need cash, and they've got property that is worth more than they owe on it on the mortgage, something called equity, then you can literally get a loan from a bank on top of the existing mortgage that you have. Some call it a home equity loan. Some other banks call it a home equity line of credit. Other banks call it a second mortgage. Whatever you want to call it, the sort of legal meaning is the same, which is that you no longer, if you have a mortgage on the home and now you have a second mortgage, in order to be able to sell that property to someone else, you can't sell that property with those two mortgages attached to it, because the person who took out the mortgage, who owned the property, who's now trying to sell it, well, they didn't contract with the bank and with the new buyer. It's just between the bank and the person who currently owns the property. And so that new buyer shouldn't have to assume that mortgage. Now, sometimes that happens, but it's very rare. Usually what happens is whoever the new buyer wants to mortgage the property with, they'll pay off that old mortgage, and that gives it free and clear title. And for free and clear title to exist, all of the debts and loans and any other encumbrances have to be taken care of, have to be paid off or resolved before that property can be sold. For example, sometimes if there's a lawsuit, and the person who's being sued owns a home, the person who has won that lawsuit against that person will file a lien for the money judgment of that lawsuit against the person's home, so that even though they may not get paid right away because the person may not have enough cash to pay off the judgment of that lawsuit, when they sell that home, that lawsuit's got to be paid off. And so any proceeds that come from that home then go to the person who won the lawsuit. And so it's a lien is a great way to ensure if someone owes you money, to get paid, basically, is they cannot sell their property, they cannot sell their home or transfer it to anybody else in any type of ownership, even an inheritance, without that lien being satisfied. And so and this is why property descriptions are so important, and this is why recording deeds is so important, is because the only way we know all of these things are occurring and that there's a lien or a lawsuit or money judgment or some other type of encumbrance on a piece of property is because it's all been recorded at the property in the public records at the courthouse. I was going to say property appraiser, but that's a totally different subject and different department. But we'll talk about property appraisers and property appraisals a little bit later in the course. But the public records directors who run the public records at the courthouse. And by the way, public records not only include, deeds and property transactions, liens, encumbrances, and other things. They also obviously handle all court documents. And this is why when you file a deed, you do it at the courthouse, because you want court records and deeds all to be in the same place so that you can match things up easily. This lien goes with that property, and you can connect the dots pretty quickly when you're doing a title search. And that's basically what a title search is, by the way. It's just simply pulling all the present as well as past records on a piece of property to make sure that title is free and clear before that property is transferred. Or if there are encumbrances on the property, that those things get taken care of before it's transferred or sold to someone else. Getting back to legal descriptions, I want to talk about one other type of legal description, and that is something called a meets and bounds legal description. And this is where, by the way, I think I touched on this last class or last lecture, and that is this idea of property surveys and surveyors. These are those folks that you sometimes see on the side of the road who are kind of looking through these weird devices known as transits or transoms. They are able to basically measure angles. And you can see there's another person on the other end kind of holding a giant stick, or what looks like a stick. It's basically a giant ruler that is able to give perspective to the person looking through the transit. And they can then judge based on how far that person is away, what the angles are to the property, and where the property lines end. And that is really super, super important, because not all property is perfectly divided up into those lots and blocks. Some pieces of property have borders on it where it could be a road that's not perfectly straight, or it could be a body of water like a river, or it could be some other type of land delineation like a crest or a hill, that again isn't perfectly straight. And so in order to get proper measurements, because let me tell you folks, if you do any research, and I don't know if we're going to have time in this course or not to do any legal research, but if you just for the heck of it want to look at some crazy lawsuits, look at neighbors suing neighbors over fence lines. um, it is crazy. And the reason is because, and by the way, people don't always know this, and you may not know this unless you've ever purchased a home or built a fence, but fencing is kind of expensive. um, and it's expensive because it's designed to be, to last a while. Even wood fences can be expensive because they're designed to last. And so it's a real bummer if you build a fence that is supposed to separate your property line from your neighbors, and yet you, by mistake, because you don't know where the property lines are properly located, you build that fence, your fence, on your neighbor's property. Guess what's happening? If they find out about that, they're going to sue you, and they're going to win, and you're going to have to tear your fence down. You're going to have to tear your fence down and move it maybe a foot, heck, maybe even only, 6 inches or so, um, just because you didn't know exactly where your property line was located. And that can be important because of that reason. Now, there are other reasons to know exactly where property lines are located, but fencing is one of the big ones. And so you'll see from this meets and bounds legal description, and this is why I kind of talked about the concept of property surveying, is because this is where those come from. You'll see in this property description, or this legal description, which is much longer, much more detailed, and the reason it is much more detailed is this is likely a piece of property that was created within a land development that didn't have perfect blocks and lots, that the lots and blocks had to be are kind of weirdly shaped, or maybe they're on hills, or near crests or depressions or mountains, wherever it could be, where assessing the perfect lines is much more difficult. And so you'll see here, I'm just going to read part of this. I'm not going to read the whole thing. You can read it yourself. But it starts with, commence at the northeast corner of the east one half of west one half of northeast one quarter of southwest degrees 03 feet 8 inches east, comma 28 feet. Oh, I think I actually skipped a line. Quarter of the section 17, township 1, north range 12 west, and run. And then I'm caught up here. South 0 degrees 03 feet 8 inches east, comma 28 feet to the south right of the way line of Silver Lake Road. And you can again read the rest. Now, that to me just sounds like a bunch of gobbledygook. And to someone who doesn't understand property law, it is. But that legal description is hugely important when you're transferring property, because what that legal description allows you to do, if you either, and for those of you who don't know, I'm ex-military, and for those of you who are former military, you know what an azimuth is. You can shoot an azimuth if you have a compass, where you can determine a distance based upon your location versus a particular land description, or a land feature, and you can determine distance. You can even determine, in some cases, elevation, and all of that allows you to kind of juxtapose where you are specifically on a map, when again, if you're in a combat zone, or even on a military exercise, knowing where you are on a map can be hugely important. In fact, it can make a difference between, in some cases, life and death. So that's one way of determining location and where things are on the globe, on a map. But when it comes to property legal descriptions, knowing where those property lines are located is, again, hugely important. And the way you do that when you don't have a perfect square to measure from is you've got to incorporate all of these different elevations and directions and waypoints so that you can either, whether you have a GPS or even pre-GPS, if all you had, again, was a compass and a transit, or just a transit and a measuring stick, you would be able to basically determine exactly where things were on a particular piece of land, and determine where those property lines are located, so that if you are building a fence, installing a water line, building a home, you name it, that you are not trespassing. And that's where that term, most of us know the term trespassing as, kind of entering a piece of property that's private, that isn't yours, where you haven't been invited. But believe it or not, if you build a fence on someone else's property by mistake, uh, that's trespass. If you build a water line and you don't get an easement, in other words, you don't have, and we'll talk about easements later on in the course as well. That is basically legal permission to build that line underneath someone's property, or to have the ability to maintain that line later on and not be charged with trespassing on someone's property. You're going to need that easement. In order to get that done, you're going to need to know exactly where everything is on the map on that particular land development. Whether there's a home there or not, you still need to know where those things are. And that property description, that legal description on that deed, will follow that property wherever it goes in its history. So if it's sold, let's say you buy two lots, right? One right next to one another. And each has its own individual land description, which it should, because one piece of property isn't located exactly where the other one is. They're next to one another, but they're not on top of each other. And so, the legal descriptions are going to be slightly different. The degrees and the meets and bounds are going to be slightly different. And the way you determine one piece of property or one lot from the other, even when you don't have a fence or another visual way to determine where things are, is through these land descriptions. But let's say you own those two lots together and you want to combine them. No, you can't do that, because what will happen is, if someone later decides to bifurcate those lots, they're going to then have to recreate that land description again, and you really don't want to have to do that. Not to mention, it can create all kinds of other types of confusion. And so that particular land description will be an attachment along with the deed wherever that property goes, whether it's bought and sold with other pieces of property near it or next to it. It doesn't matter. It will always stay the same. And some of these legal descriptions, especially meets and bounds legal descriptions, can get really long, but they're super, super important. I cannot emphasize enough how important accurate legal descriptions are when it comes to buying and selling land. It can really make the difference between someone building on their own property versus trespassing on someone else's property by accident. And trespass is a strict liability offense. In other words, it doesn't matter whether you intended to do it or not, whether you intended to build your fence on your neighbor's property or not. If they find out that you did and they can prove it in court under oath, guess what? You gotta tear up your fence and rebuild it, and it could only be inches away from where your original fence line was. But because you messed up, you're the one who's on the hook for it, and you never want that to be the case. And if you are working at a law firm where you are either the closing agent on a particular piece of property, or you're the firm doing the title search. Usually it's the same folks. Or if you are just representing the party who's buying or selling the land, you got to make sure those land descriptions, those legal descriptions, are absolutely 100% accurate. And the only way to do that is to take the old one and the new one and literally read through them both together. In fact, usually what we would do, and this is when I was working in family law, where we were transferring property from one spouse to another through the marriage, through the divorce, and we'd have a new uh, legal description that would have to go on a new document, and we'd have to literally, I'd give the old legal description to someone else, and I would read through it. They would follow along with me, and if there was a one tiny little error, we'd have to start over again and fix it and, read through it again. And it can take a long time. It's very time consuming, but it's super, super important. So let's get back to the lecture and some of the other quick things that I wanted to kind of touch on. And I think there was, oh yeah, there was one other thing. We talked about notarizations and the need that's both parties provide notarized signatures, and not just both parties, but also a witness. And again, usually the notary is the witness, that third person, but the buyer and the seller must have notarized signatures on all deeds. That is not you may do it if you so choose. No, it's a shall. You must do it. You shall do this for your deed to be valid. And then you go record that puppy. You go to the courthouse where that land is located, and you record it with the property records department there. And once it's recorded, you've got yourself an enforceable deed, and you are good to go. Now, let's talk about title. The deed is the written document. It's the one that's got to be on paper. It's the one that's got to have the land description, the land legal description on it. It's the one that's got to have the notarized signatures. Title is the legal concept of ownership. It's if the deed says on paper that you own this property, title is the legal concept in which ownership is known and enforced. And we will go into title in a more detail later on in the course. Just know that for you, again, to own free and clear title, it's a requirement for you to transfer property. Even if you want your heirs to inherit that property, it cannot be, again, transferred. In other words, you owning it to someone else owning it cannot happen until that title is free and clear of any encumbrances. And I talk about liens as, these are money judgments. These are, if someone owes you money, you can get a lien against their property if they own a piece of real estate. You can get a lien. It's then recorded along with that deed, so that whenever they do a title search, they're going to see your lien on there, and they're going to go, uh-oh, wait a minute. This person owes John Smith here $5,000. We can't sell this property until John Smith gets paid. And so then what you do is you contract to make sure that when the property is sold, that money, those proceeds, that first $5,000 goes to John Smith. It doesn't go into your pockets and then, oh, maybe I'll write John Smith a check from the proceeds. No. If you've got an enforceable lien, you can't sell that property and transfer it until there's another document that says that John Smith gets paid first. Okay. Now, what if you have like more than one debt? Let's say you're really bad at paying your bills and you've got a bunch of money judgments against you. In other words, a bunch of, let's say, credit card companies have sued you because you owe them money. Well, then it's first in time, first in right. In other words, the first credit card company that sues you, they get first dibs on any money. Then the second credit card company that sued next, and it's all based on data filing. And so sometimes there's what's called a race to the courthouse. This is where a creditor who's worried about getting paid and is suing to get paid, and they know that the person that owes them money owns a home, they're going to race to the courthouse as soon as they can to beat any other creditors to the courthouse to get that filing date, that stamp on that document that says when that lien was filed, so that they can be first in time, first in right, or at least get in line to get paid before the money runs out. Because unfortunately, what can sometimes happen is you've got a piece of property and the person who owns it owes a bunch of money to a bunch of different creditors, and yet they also want that property to be passed on to their heirs. Well, that property isn't getting transferred to the heir until all of those creditors are paid off. And unfortunately, what can sometimes happen is all of the proceeds from the sale of that property or of any value of that property can be taken up by creditors, and then there's nothing left to inherit. It can be kind of sad when some folks who uh, uh, thought they were going to inherit a bunch of money from, maybe a rich uncle or a parent, uh, realized that their parents were in a lot more debt or their uncle was in a lot of debt and they didn't know it. Why would they? And then they end up getting nothing or very little because creditors got all of the proceeds. And so that can happen. And this is why creditors, when they sue you or sue anybody, and get a money judgment, that's a court document that again gets filed in official records and can be attached to property, real property. um, you know, you can only attach things to personal property, and usually the more common thing is attaching a garnishment. That's basically taking someone's proceeds or income. In other words, when they get their paycheck, the employer takes a little bit out and pays the creditor a little bit over time, so that the creditor eventually gets paid. Um, and there are lots of rules and laws with regards to that, how much can be taken out and all of that. But when it comes to real estate, real property, that lien sticks like glue to that property until that debt is paid off. And it's either paid off through proceeds of sale, or the property is liquidated. Um, and this is where you get what are called estate sales, or property sales on the courthouse steps. Um, and the reason they reference that is because that's the way they used to do it. Um, if someone was in debt up to their eyeballs and yet they own land, the creditors could get a money judgment and a court order forcing that person to sell their land. And instead of them selling it to somebody privately, the courthouse would basically just take possession of the deed and then wave it on the courthouse steps, and people would show up and auction. It would be basically an auction, and it's a great way to get things for cheap, because usually the auction prices are a lot lower than what a sale price would be based on market value. And the problem is obviously is that the creditors don't really care. All they care about is getting paid. They don't care how much the property sells for, as long as they get their money. And the person who owns the property, they care obviously, because they are losing their land, or their real property if it's a home. But they're not getting the fair market value for it. And you could say, well, that's not fair. Well, what you do is you pay your debts. Okay. If you don't have you don't, if you don't pay your debts, you can't come back later and say, oh man, they did forced sale on my property and I hate these people because they're such jerks. Well, dude, pay your debts. I mean, you could have sold the property on the market yourself and paid your debt, and the creditor still would have gotten paid, and you would have had some proceeds left over, possibly, if you'd have just taken action. But instead, people, they fight it, or they want to ignore the problem, pretending, hoping it goes away, or maybe they think they're just going to die before a court forces sale on a piece of property. Um, you know, there are a bunch of different reasons for courthouse sales, but the bottom line is that does happen. If you're into getting cheap property, yes, you can get cheap real property at courthouse sales, but it's usually not of high quality. It's not as easy to turn over or flip as you would think. And in fact, there are lots of sob stories out there, folks, of people buying lots and lots of properties at courthouse sales, and not being able to flip it, and then getting into debt themselves and finding themselves actually on the other end of things where now their property is being sold on the courthouse steps. So that is why recording is so important. That is why deeds have to be in writing and be recorded in order to be enforceable at law. Doesn't mean it's not in, it doesn't. Let me back up for a second because I want to make sure you understand this. If you don't record a deed, it doesn't mean that the deed is invalid. You still own the property, and you still and it's still a valid deed. But for you to enforce that deed and get a mortgage or build on it on the property if it's just land, or to sell the property, it's got to be recorded. You've got to record it. And also, let's say it's land, there's no home on it, and then all of a sudden you go out to your land and you see that someone's built a home on it without your knowledge. You didn't, you hadn't visited it in years. All of a sudden you go out there and you realize, oh crap, there's somebody built a house on my land. Well, guess what, pal? You're gonna want to file a lawsuit to sue the people who built and stole your land, but you didn't record your deed. That's why recording a deed equals an enforceable lien. You can't enforce that lien against someone else and assert your property right unless it's recorded at the courthouse. It doesn't, so again, an unrecorded deed doesn't make it invalid. You still own the land, but to tell the world and to show the world that you own that property, you've got to record that deed at the courthouse. That's the difference between a deed versus an enforceable deed. So I just want to make sure that you understood that. And if you don't, let me know. I'll be happy to clarify it in my next lecture or with you individually if we need to talk about this over Zoom. So again, title is that right of ownership. It's the language in the deed that expresses your right to own it. And so quickly, we'll talk about closings. We're going to get into closings again in more detail as when we get into our section on property transactions, property sales, purchases, inheritances of property, forced sales, that kind of thing. And that is something called a closing. And you've probably heard, if you've never owned property or owned a home, and yet you've probably still heard of the term closing on a piece of property, like, oh, today's a big day, we're closing today, and oh, congratulations. What does that mean? Well, this is what it means. It means that the buyer, the seller, and then a third party, usually referred to as a closing agent. And that closing agent, by the way, can be an attorney. It's usually recommended that you at least have an attorney look over the documents, even though your closing agent may be a paralegal or a business, a firm that specializes in closings. But it may not be necessarily a law firm. However, again, most valuable property, that's property with a home on it, or property with a building on it, that's a piece of commercial property, or property that's located in an area that's valuable. Property near downtown of a big city, or property that's an empty lot, but it's surrounded by other developed lots. That's highly valuable property in any of those situations. In fact, I would just recommend kind of pull the string, and you're going to want to repeat this. If you are talking to any layperson, that is anybody who doesn't who isn't a paralegal or an attorney, and they're talking about buying a piece of land or selling a piece of land, tell them to just see an attorney. If they don't want to hire an attorney, and put one on retainer, then at least just tell them, hey, just pay a few $100, spend an hour with them while they look over your documents. Okay, pay them whatever their hourly rate is. I promise you it'll be worth it. And it is worth it because people make mistakes all the time with these documents. They're highly complex. There's lots of them. Banks lose documents all the time. They misfile things. It's getting easier now that most of the stuff is electronic, even though, again, it still has to be put on paper, that deed, it's still a possibility that these things get mixed up. And the only way to ensure that you're protected as a buyer or a seller, that there wasn't a mistake that could nullify the sale or create a situation where you're what's called buying a lawsuit. In other words, you're buying a piece of encumbered property that's either got a lien on it or some other type of encumbrance on it, and you just didn't know about it because you didn't hire an attorney or paralegal or firm to do a proper property search. Then you have purchased a piece of property where before you know it, you're being sued and you didn't do anything other than buy this land. And all of a sudden you realize you purchased a lawsuit because you didn't do a good property search. So it really is important that a good property search, which is part of the closing process, is conducted. And again, I would always tell people, hire an attorney. It's worth it. If anything, it'll help you sleep better at night because you're spending so much money on this. Look, homes, buying a home and owning a home is many people's dreams. I know it isn't everyone's, and that's okay if it isn't. But for most people, for a lot of people, it is. And a home is usually a person's most valuable asset. Even if they owe money on the home, it's still their most valuable asset because cars, although valuable, depreciate quickly. Other personal property, even jewelry and diamonds and gold and all of that depreciates or goes up and down in value based upon the market. And unless it's an heirloom or some type of really unique piece, it's not going to appreciate in value. And so land is really, and homes are really the only things where property value can go up over time generally. It doesn't always happen that way. And of course, there are always market bubbles and things like that where, the price is going up artificially, and then there's a crash, the bubble bursts. This happened in the United States in 2008, 2009, and where there's a giant real estate bubble. The bubble burst, the market crashed, and all hell broke loose, and the economy was in recession nationally for another 3 or 4 years after that. It was really a rough period for a lot of people. And so when you're buying or selling a piece of real property, it is always important that you make sure that all those T's are crossed, I's are dotted, everything is perfect. And the only way to really ensure that is to hire a real estate firm or an attorney or a paralegal who really knows their stuff and can serve as closing agent so that they do a good property search. So they make sure all the documents are valid and properly created and drafted, signed, notarized, the whole 9 yards. At closing, the biggest thing obviously is that title search. And that is where you're going to get a certificate at the end of the title search from whoever conducted it, basically swearing under oath that they've done the title search, that it's been exhaustive, that they have found everything there possibly could to be found on that piece of property, including going back 50 years if necessary, and basically being able to track who owned it first, second, third, fourth, fifth, and so on, all the way up to the present day, so that you can essentially tell the entire story of that piece of property from when it was, just land and there was no home on it, to when they first built the home. Then that home maybe have been torn down and replaced with another home, or maybe it's the same home. But the people who've owned that home, any encumbrances that were on that piece of property throughout its lifetime, and that is hugely important for avoiding that issue of buying a lawsuit or avoiding a potential challenge to the transaction. The only way to truly know that you've got all the facts is to do a proper property search, where you'll then get a certificate, a what's called a title abstract or title summary, and that is a document again that kind of goes on top of the title search documents, and it is essentially a signature by the person who did the title search, who says, "I, to the best of my knowledge and ability, ran the title search, and I could find no outstanding encumbrances or liens or any other reasons why this property can't be transferred at this time, or here are the liens and here are the contracts that are going to wipe out those liens and those debts after the property is sold and changes hand and the money changes hand. And they're going to get paid first, which is part of the deal. Remember what I said about creditors. They get paid first before the seller gets any of the money. The seller doesn't get to choose who gets paid if there's a money judgment or lien against them on their property. That is up to, again, that first in time, first in right standard. And so a closing, again, is that culmination of all of the property search, or excuse me, the title search, the land description, the signed and notarized signatures, a bunch of other formalities that have to go into a deed, the type of title that the owner is going to inherit, or not inherit, but take over, and anything else that could be important to that particular sale. Of course, there will also be documents with regards to the mortgage on the property, the old mortgage that's being paid off through the sale, as well as the new mortgage. The new owner went to a credit union instead of a bank, and maybe it's a different loan based on different interest rates. And all of that language is going to be in a different document called the mortgage contract. And that is where the person is borrowing money from the bank and they'll make monthly payments until that it's paid off. And then guess what? They own that property free and clear. But remember, you can still sell your home even if you own money on the mortgage. But like I've been saying, you just have to make sure that mortgage gets paid off before that property can be sold to someone else. And again, most mortgages, 99.9% of mortgages that are in existence at the time of the sale transaction are paid off through the proceeds of the sale of the property to the new person. And we will go into all of this in more detail as well as we get into the section on land transfers and transactions. Let's see, piece of real property. Oh, this is the free and clear title, which we've talked about, and liens and other encumbrances. And again, an encumbrance can be, again, a divorce final order that says that the wife still has an interest in the sale of the home, and that she'll get paid her interest when the home sells to someone else. And so, and it's just in some ways, if there's enough cash in the divorce, a judge will say that one of the spouses will get paid through the proceeds of the sale of the home. And so she sort of lines up like a creditor, and that property cannot change hands to someone else until that ex-wife or ex-husband gets paid per that court order. So it doesn't have to always be a lien. It can sometimes just be a court order or some other type of order from a judge with regards to a divorce, or maybe it's a probate estate where someone has passed away and they want to pass on that property to their heir. Well, again, all encumbrances have to be taken care of before that heir can assume possession on that piece of property. Okay, real quick, I want to finish up by talking about title and concurrent ownership. And I'll go over this in more detail as well throughout the rest of the course to make sure that you understand how joint tenancies work and the different types of joint tenancies. But basically, concurrent ownership means that you have two or co-current owners, concurrent. You have two owners of a single piece of property at the same time. Usually the two owners are related in some way. They're either spouses or they're brothers and sisters or cousins or a parent and a child, niece, nephew, you name it. Usually it's not just like two complete strangers who purchase a piece of property together. It happens, but it's very rare. And So I just wanted to quickly kind of go over what a joint tenancy is, the different types of concurrent or joint tenancy or concurrent ownership. Same thing, joint tenancy equals concurrent ownership. Uh, and what a right of survivorship is. And then finally, we'll finish up by talking about a life estate. A concurrent ownership means, again, that there is some sort of joint tenancy that you own the property with someone else. Usually it's a family member of some type at the same time. Now, I personally own a home. I'm currently not married. I don't own it with a spouse. It's just me. However, if I wanted to, since Florida doesn't have common law marriages, let's say I had a girlfriend and I wanted her to own part of my home because I want to spend the rest of my life with her. I intend to spend the rest of my life with her, but I don't really want to get married. You can do that. That would be a certain form of concurrent ownership, where I would have to change the title, the deed of my home, and the title, the concept of ownership to include her with me in the ownership of that home, even though, again, we're not blood relatives and we're not married. You can still do that. And again, common law marriage, just kind of going back here for a second. Common law marriage is basically a legal acknowledgement of two people who have never officially gotten married, but have spent so long together as a couple and own property together as a couple that it's basically just like being married. And they call that a common law marriage. And it's basically marriage, but without the wedding and the marriage license. Um, and Florida does not recognize common law marriages, so I'm not really going to go into that a lot. But that's where that term comes from. But you can still have a joint tenancy with someone you're not married to if you want to kind of pretend like you have a common law marriage. And look, I'm not going to tell people how to run their lives. I have no business telling people how to run their lives. I've made enough mistakes myself with my own life. Um, but I would not recommend with a piece of real property, your most valuable asset, if it's what you own and you're the person coming to the relationship with that piece of real property, you love that person, you want to spend you intend to spend the rest of your life with that person. If you're going to do that and you want to make them a co-owner or a joint tenant in your property, go ahead and just marry them. You're going to have more rights in Florida, especially uh, to defend against that person running off with your property and establishing a true interest in that property if you're married, as opposed to you making them a joint tenant legally in your property, in the ownership of your property. But again, that's up to you. And again, everybody can make their own decisions in life, but that is an option if you so choose to do it. And so there are several types of joint tenancy. The key distinguisher is this, and we're not going to get too much into the minutia because I don't want to go over an hour on this lecture. And also, we're going to have more time to talk about this, but there are going to be several questions that you want to ask and understand before you determine what type of title a joint tenancy is. For example, with a tenancy in common, there's no right of survivorship. In other words, if two people, and I think I put in the written lecture that it's sort of like roommates, but instead of renting the property together, they own it together. And this would sort of be that example I just used, where you're not married, but you want to make that person part owner of your home. You would create a tenancy in common. But the key with that, with no right of survivorship, is that with a right of survivorship, if let's say one person owns 50%, the other person owns half or 50% of the property, when with no right of survivorship, when one of the two people dies, that other person, the person who's alive, who still owns their 50% of the property, does not automatically then inherit or assume the other 50%. Without a right of survivorship, that person's property who died, that person, their half interest goes to their heir. So whoever that person's heir would be, it could be a son, a daughter, it could be a niece, nephew, it could even be a parent or another type of relative if they don't have any offspring, any children. Um, and so having a right of survivorship with a joint tenancy is kind of an important and a big deal. And it's what distinguishes a tenancy in common versus a tenancy by the entirety, or what is known as a joint tenancy with right of survivorship. And that is, again, this idea of a right of survivorship and what happens to that person's interest after they die. With a right of survivorship, let's go back to that same example where you've got two people who each own half or 50% of the property. Okay. With a right of survivorship, that person who passed away and before, when they didn't have a right of survivorship in the title, that interest went to their heirs. Well, with a right of survivorship, the person who dies, their 50% now goes back to the person who owned the other half. So, in other words, instead of the two people owning it, one person dies. Now, this person who's left, who's still alive, now owns 100% of the property. That's why a right of survivorship is so important in some of these documents. Now, some folks don't always want to do that. They want to, allow the other person to be able to transfer or bequest their interest in the property to their heirs, and that's perfectly okay. But with a right of survivorship, what you're doing is you're ensuring that the person who is left behind of the couple, and again, it can also be more than just two people. Let's say it's three. Uh, Again, with that right of survivorship, if it's three people, well, now you're dividing the property into thirds, right? Each owns 33.333% of the property. Okay. So now you've got, I'm trying to put the fingers up so everybody understands. You've got 1, 2, and 3. Each own 33.33% of the property. Without a right of survivorship, these two people, 1 and 2, they still own 33.333% of the property. The third person who died, guess what? Their property, that 33.33%, goes to that person's heirs. The other two, their property interest doesn't change at all. Whoever inherits that property takes over as that third person. Whereas if you have a right of survivorship, and again, it's 33.33, 33.33, 33.33, now that third person dies, those other two people, they inherit that person's share equally. So that 33.33 is what? 15, 16 something, 16%, let's just say 60%. They then would each get that person's share equally with the right of survivorship. So, and again, you can divide it up 4 ways, 5 ways, 10 ways if you want. With a right of survivorship, the property goes and kind of doubles back around. Those property ownership title rights go back to the people who are still alive. Without a right of survivorship, the property continues to go down to that person's heirs. And that is why whether or not there's a right of survivorship in the title is so important. The other thing I think that's important to know is whether or not the people are married. Getting back to that first example where I kind of was joking about whether or not you want to create kind of your own version of a common law marriage here in Florida, even though Florida doesn't really recognize common law marriages, by again changing title to your property and giving that person an interest, an ownership interest in your home. You now basically have a joint tenancy, and it could be with a right of survivorship, or it could not be, depending on, again, what your desire is. But when you're married in Florida, and this is automatic, you don't get to choose whether there's a right of survivorship or not. If two people who are married purchase a piece of property together, it automatically becomes selection, I think it's C, um, excuse me, D, what is known as a tenancy by the entirety, which is basically just another fancy word for it's a married couple who owns a piece of property and it automatically becomes with a right of survivorship. There's no choice. You don't get to choose. In other words, um, a husband and wife own a piece of property and they have one child. Let's assume it's a son. Um, if if a tenancy by the entirety didn't have a right of survivorship, well, then that if the wife died before the husband, then the son would then inherit the wife's 50% share. Well, that's not going to happen because tenancy by the entirety with two married people automatically creates a right of survivorship. And so the husband basically inherits the wife's share. Now, the son will inherit after the husband dies, but not until that happens. Um, and there are other things that the husband can do to ensure that the son has an interest in the property before he dies, but we'll get into that. That may be for a probate course. And if you've taken my probate course, you kind of know what I'm talking about. It can get very complicated very quickly. Just know that with a married couple, it's a tenancy by the entirety. That's the formal legal term. And it always comes with a right of survivorship. So those two questions again are, is the concurrent ownership or joint tenancy, does it have a right of survivorship or not? If it does, you know how the property is going to work when someone dies. And if it doesn't, you know how the property is going to work if someone dies. And if it, whether or not the people who have the joint tenancy are married or not. Because you know if they're married, then it's going to be a tenancy by the entirety and it's got to have a right of survivorship. So you don't even have to ask the first question. In fact, you may want to just start off by asking, are they married? Yes or no? No? Okay. Then move on to the question about whether or not there's a right of survivorship or not. I know that all sounds complicated and I know I've moved through it quickly. I'm going to probably talk about this in more detail as well as we continue on with the course. So if you are still a little bit lost on concurrent ownership and joint tenancies, let me know. Please send me an email. I'll either meet with you personally by Zoom or I'll just record a quicker, slower lecture, probably with some charts to better explain it. And I definitely want to make sure that you know this before the midterm. So please do not be afraid to ask. One last thing before we go, and that is what's called a life estate. And the reason this is important is because it is the only form of concurrent ownership where the person who is living in the home doesn't own the property, doesn't own an interest in the property or an ownership interest in the property. And a life estate is primarily for someone who either owns a home and has to and is trying to give ownership to an heir before they die. And you can only do this if it is a single person. If it's a married couple, obviously you can't do it because the spouse would inherit first. But you can create a life estate for that purpose. Another purpose is if you have a relative who doesn't have a home and they're literally homeless or they're paying rent and you want them to live in your home and you're not living there and you want them to have the right to live there until they die, but you really don't want them to have ownership. And the reason that's important is because an individual who has a life estate to reside in a home for the term of their life can't sell it. They can't mortgage it. They can't get a lien on it. They can't encumber the home in any way because they don't have an ownership interest. The only thing a life estate gives them is the right to reside in the home, live in the home for the period of their lifetime. Also, with a life estate, there are a bunch of other add-ons or caveats that you can add on to make sure that person does or doesn't do certain things. For example, there's a home and it's owned, you own the home, but you have a cousin, and you're not living in the home, and that cousin is homeless and needs a home, and you want your cousin to live there, but you also know that your cousin's got some issues. They're bad with money, or maybe they've got a drug or alcohol problem or a gambling problem or something that has kind of led to them being homeless. Um, but you still, they're your cousin and you want to help them, but you only want to help them enough to where they've got a home, but not enough to where they could really create more problems for themselves or for you. And so you would go to your attorney and have a life estate created for them, where again, the document would say, you know, Joe can live in my home until his passing or until his death, uh, so long as, and there could be a bunch of caveats, so long as Joe abstains from alcohol and drugs, so long as Joe doesn't gamble. And then if they violate the life estate, you would literally have the power to evict them, to have them leave, and make them leave, because they violated the terms of the life estate. So there are a bunch of caveats or tags or add-ons that you can attach to a life estate if you want to give someone the right to live in your home uh, during their lifetime, but you don't want them to have an ownership interest, so they could sell it or mortgage it or get a loan on it and therefore have a lien on the property. And also, if you want them to do things or not do things, um, you know, not doing things that could be harmful to them, or to do things that could be maybe good for the property. I've seen life estates where, in order to be able to live in the home, they had to maintain the lawn, and they had to maintain the shrubs and the landscaping, to keep the place looking nice, to keep it in line with maybe the HOA requirements, and to increase the property values so that when that person does pass away and that home can be sold, that the property is ready to go and can be sold immediately. So you can make a person do things with a life estate. You can also make them not do things with a life estate and add those terms on there. But again, a life estate is simply gives a person the right to reside in a home during their lifetime, uh, but they don't have any ownership interest other than the right to reside there. They can't sell the home, they can't get a mortgage on it or a second mortgage or borrow money on it in any way or encumber it in any way. And if they got sued for some reason, um, the person suing them could not attach a lien to the life estate because, again, they don't have an ownership interest. All they have the right to do is live there. And again, though it can be based on certain conditions or preconditions to either do something or not do something. So that's a life estate. And again, I just kind of wanted to cover that pretty quickly as well, because a lot of people have probably seen that term before, but just don't understand how it works. And by the way, if any of you are curious about reverse mortgages, that's sort of the way reverse mortgages work. This is usually for folks um, who are up there in age, who need cash. Is a bank will basically assume the ownership interest over the home, give the person a life estate to continue to live there until they die, with the caveat being that once those people die, uh, the bank gets the home. Or the mortgage, that reverse mortgage has to be paid off before it can be transferred to the person's heirs. And so, yeah, I think reverse mortgages are a little shady. That's just my personal opinion. Uh, I'm sure you could find lots of information out there about or about reverse mortgages where people love them. It's just one of those things. But we can talk about all that stuff and everything else we've covered today in more detail later on in the course. Remember, midterm coming up next week, May 30th. Study guide probably going to come out early next week. But if you have any questions or need anything between now and then, please contact me. Let me know. And I hope everybody has a great day. Take care, everybody, and I will talk to you again soon.